is Samantha Dowling, and I'm going to be talking with you about the Second Amendment, which is the right to keep and bear arms. As you know, the Second Amendment is part of our Bill of Rights of the Constitution of the United States and has undergone a lot of scrutiny today due to the violent acts that have been committed with handguns and assault rifles over the past several years. The Second Amendment is the only amendment in the Bill of Rights that begins with a preamble. It reads, "A well-regulated militia, being necessary to the scrutiny of a free state, the right of the people to keep and bear arms shall not be infringed." It's debated, though, however, whether or not the Second Amendment referred to the rights of states to have a militia, or whether it was an individual's right to own and bear firearms. I think it's worth mentioning that James Madison drew from Samuel Adams and Thomas Jefferson when he was writing the Second Amendment. In the amendment that was offered by Adams at the Massachusetts Convention, he wrote, "And that the said Constitution be never construed to authorize Congress to infringe the just liberty of the press or the rights of conscience, or to prevent the people of the United States who are peaceful citizens from keeping their own arms, or to raise standing armies unless when necessary for the defense of the United States or of some one or more of them." In Jefferson's proposed Constitution for Virginia, he mentions that no standing army should exist except in the time of actual war, and said no free man shall ever be debarred the use of arms. He later amended this statement to say no free man shall be debarred the use of arms within his own lands or tenements. However, the right to bear arms is not without limit, because there are public regulations that controls the types of weapons that are lawful and the conditions of which those weapons can be kept. However, there are no regulations that can be made to overthrow the right itself, and the U.S. Constitution keeps legislative bodies from prohibiting the right to own firearms. In 1939, the United States versus Miller, the court asserted an interpretation that does not fully endorse the right to keep and bear arms and falls short of fulfilling the intentions of the amendment's framers. The court ruled that the individuals may justify reliance on the amendment in keeping only such arms as a member of a militia might use, like shotguns, rifles, and handguns. However, it does not allow them to own short-barreled or sawed-off shotguns under 18 inches in length, a machine gun, a bazooka, a cannon, or assault rifles. In 1951, in Dennis versus the United States, the Supreme Court determined that it is within the power of Congress to protect the government of the United States from armed rebellion is a proposition which requires little discussion. Then, in 2010, a court decided in the case of McDonald versus the City of Chicago, McDonald had challenged whether or not the handgun ban in Chicago was constitutional or unconstitutional. The court cited the intentions of the framers and ratifiers of the 14th Amendment, held that the Second Amendment applies to the states through the incorporation doctrine. However, the court did not have a majority on the clause of the 14th Amendment incorporating the fundamental right to keep and bear arms for the intentions of using firearms for self-defense. Today's information on the Second Amendment was sourced from the journal article The Ideological Origins of the Second Amendment by Robert E. Shalhope, then also the Legal Information Institute website, and also Origins of the Bill of Rights by Leonard Levy. I hope you enjoyed and have a great week.